In 1996, Bill Gates said, "Content is king." And boy, was he right. 3 decades later, it still occupies the throne. For lawyers, law firms, and companies serving the legal industry, content marketing and thought leadership marketing are a must if they want to build their books of business or increase their revenues. Hi, I'm Wayne Pollock. I'm a former Law 50 senior associate who discovered the world of content marketing and thought leadership marketing and hasn't looked back. In each episode of this podcast, I interview lawyers and legal industry in-house marketers who are doing big things with their content marketing and thought leadership marketing. This is Legally Contented. Hello and welcome to episode number 2 of Legally Contented. I am your host, Wayne Pollock. Being a big law lawyer is not for the faint of heart. You've got thousands of billable hours a year you've got to put in over the course of probably a decade. You've got a decade's worth of dealing with adversaries, opposing counsel, third parties, your own clients, your colleagues, your family, all of these tensions, all of these pressures weighing on you, and yet you somehow make it up the mountain. You've beaten the odds and you are at the top, or at least for now, the top of the mountain as a partner. We'll see if maybe you need to go even further to become an equity partner, but that's a different story. When you get to the top of that mountain and you are a partner, you're going to have to continue to market yourself and to build your book of business. And obviously there are a number of ways to do that, and this podcast covers many of the ways that lawyers can build their books of business, or attempt to at least, as partners. Well, what about writing a book? What about taking time out of your extremely busy life as a big law partner to write a book? Well, my guest in this episode, Christopher Ruhland, did just that. He wrote the Attorney-Client Privilege Answer Book, which is published by Practising Law Institute. It was first published in 2015, and the most recent edition was published for 2022. Chris is currently a mediator at Apollo Dispute Resolution, a firm that he launched in October 2021. Prior to that, he was a partner for a decade at Deckert, which is where he and I first crossed paths. Prior to Deckert, he spent 7 years as a partner at Orrick. He worked for 5 years at the Walt Disney Company as senior counsel handling IP. And prior to Walt Disney Company, he was an associate at Orrick for about 4 years. In this conversation, Chris describes the process that he followed for writing the Attorney-Client Privilege book. We talk about how a big law partner can find the time to write this book. We talk about the importance of the publisher, the role of that publisher, the work involved in writing a book, how a big law partner can use a book as a marketing tool. And we also get into a very brief side conversation in the beginning of the discussion about moving from private practice to an in-house position and then back to private practice. I hope that you find this conversation with Chris as enjoyable as I did. And certainly if you're a lawyer contemplating writing a book that is relevant to your legal practice with the hopes of it helping to build that legal practice, this conversation is going to be helpful. Here's my conversation with Christopher Ruhland. Welcome to Legally Contented. I'm your host, Wayne Pollock. I'm here today with Christopher Ruhland. Chris, great to see you. Please introduce yourself and tell us how you got to where you are today.
Thanks, Wayne. Great to see you too. So I've practiced law for almost 30 years. I have had a number of different roles in-house at big law firms. I was at a smaller law firm for a short period of time. And now I am a mediator with my own firm, Apollo Dispute Resolution. And it's been quite a journey for 30 years doing all these sorts of things. And that's where I am.
Well, I want to hear about your trip to Apollo, but you're awfully modest here. You were an associate and a partner at Orrick, which is one of the most profitable, most innovative law firms in the country. You were a partner at Deckert, which is where you and I first met, another very profitable, very prominent law firm. And oh, by the way, you spent 5 years as senior counsel at the Walt Disney Company. I think some people have heard of that company. So you're awfully modest in your background. I want to dive in again to Apollo into Apollo. And the reason why I asked you to come on and chat with me is because you wrote a book while you were at Deckert called the Attorney-Client Privilege Answer Book. And you did something that big law partners rarely do, which is you found a way with your busy schedule to write a book, and not just a chapter to a book. You wrote the whole darn thing. So I want to dive into that in a moment, because I think there's a lot of lessons there about content marketing and thought leadership marketing for lawyers and law firms, and lawyers actually attempting to write a book. We see this often with smaller law firms. There'll be personal injury attorneys or criminal defense attorneys write books, but I don't see very often big law partners taking on that role and writing, again, the whole book themselves, not just contributing to a book. So I want to dive into that in a moment, but I want to hear you were leaving private practice to go in-house and then go back into private practice. Can you walk us through a little bit about how you made that transition and what struck you as interesting about the in-house position at Disney, and then what brought you back out into private practice?
Sure, I'm happy to. And of course, so much in life is serendipitous, right? I was at a law firm, Reardon McKinsey, at the time when I was about a fifth or sixth year associate. And I was happy. I wasn't looking to leave. I picked up the phone. This is before you could see the phone number of the person who was calling me. The phone, it was a recruiter. And my practice was when a recruiter called, I was always nice to the person, even if I was not interested, and I would just hang up as some people would do. But this woman called and she said, "Hey, how would you like to interview for an in-house job at the intellectual property department at the Walt Disney Company?" And I just thought it would be insane not to do that interview. I don't know how she found me. I was doing IP litigation at the time, but I said, sure. And I went over there and I just loved everyone I met. And I thought this would just be a great opportunity to practice intellectual property law at one of the most significant and important intellectual property law owners in the world. And so I jumped in and I loved working at Disney. It was super fascinating to see the other side of the coin, to see the client side of it, and to see the business side of it. And I was there for 5 years. And after about 5 years, I did start to think that I was missing something. There was something left undone with me at law firms. I went to law school because I wanted to be a trial lawyer. And I had had some great experiences as an associate in court, but I hadn't gotten the whole experience. And so I was in court watching lawyers who represented us and thinking, I want to do what they're doing. So I went back and I went to Orrick, where I had been an associate before. And that started me down a path of doing the things that I had dreamed of doing when I was a child and watching lawyers on TV. And I wanted to become a first chair trial lawyer. And that's what I did become. And so that's how that developed.
When attorneys go from in-house back to private practice, often they'll say how they've learned so much about seeing the world from the client's perspective. They were in-house, now they're back in private practice. They understand what clients are looking for. I'm curious, that's, to me, seems like a natural fit if you went to do corporate work on the private practice side. But as a litigator, how did your in-house experience color the strategies you may have employed, or even the way you reached out and dealt with your clients?
Well, one thing I experienced at Disney was being the client, right? Because even though I did IP work and IP litigation, while I was at Disney, I didn't actually go into court and argue motions or try cases. I supervised a lot of litigation. And I learned what it's like to be that person who is responsible for results, but who doesn't get to go into court, right? And what I used to tell outside counsel was just, please don't make me look bad. I hired you, I'm supervising you, I'm involved, but I can't be the one to execute. And now at the same time, my bosses at Disney were going to be looking to me. They weren't going to be looking to outside counsel if something got messed up. They'd be asking me why it got messed up. So it's really a very difficult position to be in. And so I was very sensitive to that when I left. And that I think that's the main thing, was just a sensitivity to how in-house counsel feel and what is important to them and what motivates them, that I learned firsthand, that I think helped me relate to in-house lawyers when I went back to Orrick.
Okay. I want to jump to what you're doing right now, because we'll come back to Deckard. You were there for about 10 years, and that's where you wrote the book that we're going to be talking about. But talk to me about your mindset as September 2021 rolls around and you're thinking about what's next. What made you want to create your own mediation shop?
I think there were a couple things that went into it. The first was that I think it was time for a change, in that I had done all the things I wanted to do. The fact that I was some kid from a relatively small town who clients would ask me to fly from LA to New York and try a case in front of a jury in a huge case, that was just amazing to me. And I got to do it, and I got to do it several times and do some really cool things. But I thought at some point, do I have to keep doing this all the time? Can I do other things? And mediation is something that I thought about for a long time because, of course, as a litigator, I'd attended a lot of mediations. And to be honest, I was dissatisfied most. I thought most mediations I attended were a waste of time. I thought that they were unproductive, and I thought it was a fault of everybody involved, the mediators, the lawyers, the clients. And I just thought there has to be a better approach to this. There has to be a different approach. And so I spent a lot of time before I made the jump reading books about mediation, negotiation, and really thinking about the experiences I had. I didn't want to just do the same thing that everybody else did. And I decided to have an approach where I was going to really look at understanding both sides, really trying to appreciate who they are, what they care about, as opposed to somebody who comes in and tells both sides, well, you've got all these weaknesses in your case, and tell the other side, you've got all these weaknesses in your case, which is part of it. But I want to do something different, and I really wanted to help resolve cases because I saw the waste as well that happens in litigation. So it was out of a desire to do something different and to do something I thought I would be good at and where I could contribute. And so that's what I did.
I remember fondly the first mediation that I attended as an associate at Deckert. It was in New York. We were at the offices of a well-known provider with 4 letters in their name. And it was an esteemed judge. And the esteemed judge would come in and talk to us, the members of the defendant counsel team. And then he would go out, and a half hour later, he would return because he was talking to the plaintiff's attorneys. And I thought to myself, now I was a third year. This was my first real mediation. I thought to myself, this is it. Like, this is it. Like all the work we did. And it's just like back and forth. So I would have to imagine there are many other attorneys who saw the world from your perspective, which is there's got to be a better way here. And what's interesting, most of the mediators that I see, or at least the ones that are out there marketing themselves, are former judges. It's just like the same dispute or the same kind of issues you see where you have judges who didn't practice criminal defense, or they were only prosecutors. They were never criminal defense attorneys. You see that, I think you see that with mediators, where if the mediator has been a judge for the past 30 years, then are they as well positioned, putting aside their esteemed judge history, are they as well positioned as someone like you, a litigator who has litigated big cases more recently and understands more of the mindset that counsel and their clients might have?
And many of them are outstanding, but I suppose my point, or one of the points that I raise with people, is, are you really going to be intimidated into settling a case by the fact of the mediator's former office, right? So, and I think the answer is no, right? So if I go into a mediation, where I would go into mediations with very experienced former federal judges, there's no way they understood the case as well as I did. And who would expect them to, right? I've spent 2 years on the case. They just picked it up. And I've got my clients sitting there. And anybody who would try to really browbeat me or intimidate me or tell me that I should settle, look, I would just push back. And I'm not going to sit there and say something to my client that I think is wrong just because a mediator has imposed his or her will or tried to. I wrote an article about this on my website called "Why the Mediator of Your Dreams Could Be a Nightmare," and it really applies to both sides. What you want is somebody who can try to really understand the parties, to listen to them, and to get them involved in finding solutions. The other thing I would say is about why I did this is the pandemic showed us that we can do these online. And it was such a remarkable change, because the thing about mediations is, you mentioned New York. Well, somebody's got to fly. Where's the client? If the client's in San Francisco, the client would have to fly from San Francisco to New York. Everybody gets in a conference room. There are airplane fares, hotels, meals. I started doing them as a litigator online during the pandemic and thought, wow, this is so much better. It's so much more efficient. It works well. You could still settle cases, and we don't have to sit in a conference room all day. And so that was an eye opener. And that's another reason why I jumped into this, because I really believe that after the pandemic, we're still going to do mediations online, and we should.
That's great. And I want to now go back in time pre-pandemic when it was still acceptable to shake people's hands and give them hugs and not feel like you're going to be running into any health issues shortly thereafter. I want to go back to when you were at Decker, because that's when you wrote the first edition of Attorney-Client Privilege Answer Book. And I'm curious, what is the most recent edition?
The most recent is the 2022 edition.
Okay, so we are staying up in the times. Let's go back to that point. Talk to me a little bit. At that time, you lateraled from Orrick to Decker, and much like at Orrick, I'm sure there was you had the responsibility of trying to market yourself, to develop business, to bring in clients. What were you doing at the time for your marketing and business development, and how did the idea of writing a book enter into your consciousness?
Yeah, it happened in a really strange way, I'll tell you. Again, as a lot of things do. But what happened was when I was at Orrick, I would write articles and I was very busy. I think I had a streak of something like 15 years where I billed over 2,000 hours a year. But I would find time to write articles and I would find time to offer CLE presentations to clients or potential clients. And I thought those, especially the CLE presentations, were good touch points. So there was a client who asked for a CLE on the attorney-client privilege, one that I had not given before. So I put together some slides. I would hate to look back at those slides and see what they look like, but I put together some slides and I did the CLE. And then I thought, I did the CLE, I already did the work for the slides. Why don't I write a short article? I think this is how a lot of business development works, is that if you do one thing and you put in the time, why not do something else that's related to it, right? Why not take a CLE and make an article or vice versa? So I wrote a very short article, I think it was 2.5 pages, on in-house lawyers and the attorney-client privilege. And that was published by Law 360. Then I got an email sometime in 2013, I think, from PLI just asking me to write this book. So I wasn't thinking about writing a book. In fact, at first I thought the email might be spam, but it wasn't. It was PLI apparently had the idea that they wanted an attorney-client privilege answer book. PLI has a series of answer books, and I guess they did a search on the internet and found my article and thought, well, this person wrote an article. Maybe this person knows something. And that's what I think is so interesting about marketing yourself. One of the things that is interesting is you can become an expert by just deciding that you're an expert, right? If you write something, then you're an expert. And so they thought apparently that I was an expert on the privilege. And I thought about it for a while as to whether I wanted to do this because I thought it would be a lot of work, and it was. But so that's how it came about. They came to me, and really it all started with a client asking for a CLE.
That's amazing. That's really amazing. And it's funny you mentioned about you can become an expert by just writing something. I like to say that attorneys, when they want to develop a niche or they're thinking about pivoting their practice, they can call their shot like Babe Ruth did in the 1932 World Series, where if you're an attorney who is suddenly writing about cybersecurity issues or attorney-client privilege issues or IP issues, there becomes an assumption by the people reading your content that, well, gee, I guess Chris is doing this kind of work because why would he, as a criminal defense attorney, write about cybersecurity issues affecting tech companies? It's real interesting that when you start putting yourself out there, you get that kind of flywheel where you put yourself out there, you're doing the work, you're researching, you're perhaps getting client work that touches on that niche or that area. And then that client work gives you more experiences to write about, more conversations about that area of law to write about. Hopefully, as you become more prolific publishing material on that area of law, more clients come to you and just the flywheel continues. But It's fascinating to me that you had PLI come to you and ask you, are you interested in writing? So the question is, when they first said that to you, once you realized this was not a spam email, this was a legitimate email, what are you thinking? Gee, I've got a ton of things to do. I don't need a book. Or what was your mindset when they first asked?
Yeah, I didn't give them an answer for 2 or 3 months. I really thought about it because on the one hand, I knew I was very busy and I knew that writing this book would involve spending a lot of time on weekends and at nights trying to write this book. And I didn't necessarily relish that idea. On the other hand, I thought, okay. Oh, and also, by the way, it's not as if the attorney-client privilege was something that I had a fetish for. It's not, again, a client asked for a CLE, then wrote an article. But then I thought, well, if I write this book, that would be pretty good, because then there would be business development opportunities coming out of it. And also, I'd be a published author. If I ever wanted to write another book, I would be able to say that I wrote a book and that it was published by a real significant publisher. And so those were the thoughts that I considered. And ultimately, of course, I came down the side of writing the book.
So walk us through the process. You finally say yes. PLI is thrilled because the person they want writing an attorney-client privilege answer book finally said yes. Tell us how the process then began and how you proceeded through it.
Right. So that was interesting too, because PLI, they just said, write the book. They gave me one of the other answer books to show what the format was. They have a certain question or an answer format that they like, and they wanted me to write it in that style. But that was it. And I could do whatever I wanted to do. My first thought was, I'm going to see if I can get a lot of associates at Decker to help me with this. And I want to be careful about the way I say this, that I did get a lot of help, but not all the help was helpful. Let's put it that way. Ultimately, what I got, and partly because associates are busy too. And so I understand that. So when you get people and you ask, hey, do you want to help out on this? People say yes, but then they get busy and their name's not going to be on the front cover of the book. And so I really do understand it. It's just that the gap between how I thought I was going to write this book, which was people were going to do a bunch of drafts and I was going to edit them, and then all these chapters would just come together that way. And what actually happened, was significant. I mean, what actually happened was a lot, and researched a lot, and read a lot of cases. And I did have some people, especially toward the end when I needed it, when I had a deadline, help me out and do research and do some writing. But the fact is that I think if you're going to write a book, you need to be responsible for writing the book. And it just really can't be outsourced. And so I learned that firsthand.
Well, as an associate who might have been on the receiving end of those kinds of solicitation emails for help, I can promise you many of us probably rolled our eyes and said, oh, great, non-billable time spent helping a partner do his cool marketing and BD activity while we, the poor associate, need to scramble to make up for those 5, 10, 20, 50 hours that we spend helping good old Chris with his little pet project.
Sure. And I totally understand that. And that's why I say I wanted to be careful about the way I say it, because again, in some people, there were a couple of associates, 2 or 3 associates who actually contributed significantly toward the end, especially, and others who their hearts were in the right place. But again, I understand it. And as I said, if you're going to write a book, you need to take ultimate responsibility for writing the book, which I did.
Tell us a little bit about how you went about doing the research and writing. And the reason why I ask is because I could imagine the number of things that were pulling at your time, whether they are client matters, whether they're family matters, whether they're normal management issues and overseeing associates. How did you find time to not just pull cases and look quickly and outline, but actually sit down to write? Because if anyone has ever tried writing at 6 o'clock at night, if they're a morning person, they write at 6 o'clock at night when their brain is fried. It's like you're typing at the keyboard and the words coming out on the screen do not make sense. They're not really English words. That's not a sentence. So I'm curious how you were able to maximize your efficiency when you had all of these things coming at you as a BigLaw partner.
Yeah, so it was difficult at times, but I will tell you, a lot of it got written on weekends, and a lot of it got written on weekends in the office where there would be no distractions, and where I would tell myself, I'm going to get in the office at 9 o'clock in the morning, and I'm going to leave the office at 5 o'clock in the evening or whatever it is. And between that period of time, all I'm going to worry about is this book. And so that there was a period of time where I spent a lot of weekends in the office writing this book, and there's just no way around it, really. And then I did spend some late nights reading the book, writing the book. And maybe I would start at 6 or 7 and leave the office at 11. A lot of that, to be honest, wasn't fun. And I I don't know that if I knew exactly how much work it was going to be and how much pain I was going to suffer, I'm not sure that I would have done it if somebody told me up front. But once I got into it, I thought, okay, well, I have to do this. I committed to doing it. I'm doing it. So you know how it goes. You're into something, so you just do it. And that's what I that's what I did. Now, uh, PLI publishes these books every single year. So this is the 2022 edition is the 8th edition. It's a lot easier that every year because what I do is I probably read 200 or 300, 400 cases about the attorney-client privilege a year, and then I put about 100 of them in the book, and I update it in various ways. But it's a lot easier to do the annual.
Sure. Do you have a sense of how much time, either from an hours perspective? I'm sure do you have a sense about the hours? And also, can you give us an idea of the time that PLI gave you from when you said, yes, I want to do this, till you had to turn in something to them that looked like a manuscript or looked like the rough outlines of this book?
Yeah, I can't remember a lot of those details. We were talking, this is back in 2014 when I did most of this work, but I remember some things about it. One of the things the PLI was very good about the time, and they gave me a lot of time in the first place, and I think I told them I couldn't finish it within that time, and so they gave me more time. And then they said, do you want even more time than that? And I said, no, I want to get this done. So I could have even extended that second deadline, but I decided that I just wasn't going to. I was going to have something firm. It was, I don't know what the grand total was, the amount of time I spent getting that first one done. Maybe it was 6 months or something like that. I can't recall, but it might have been somewhere in that.
And what kind of assistance did PLI give you? What resources were made available to you to help you both in this initial research and writing phase, and then tell us what happens after you complete your task, you submit this manuscript, whatever, where does it go from there?
So to be honest, and I don't think this is a bad thing, I'm not complaining about this. I'm not sure they gave me much assistance at all, which was fine. I know that there are other legal publishers who handle things differently, and it's possible that PLI handles things differently with different types of books. But with this one, it was really hands off. I mean, I just did it, and I sent them Word documents or chapters. They turned those Word documents into PDFs. They might have sent me some suggested edits, but I went back and edited it several times after the initial and made sure or tried to reduce the number of errors. Again, I'm not sure that if you have the 2015 book at this point, you probably want to upgrade to the 2020 book, but 2022 book rather. But it was pretty hands off from their perspective. They were responsible for putting the book together and really marketing the book, right? Because the thing that's great about PLI is they have this incredible network of law firms, libraries, other institutions in the legal industry that they can market to very easily. And frankly, many of them are already on board for buying their books. So that's something that I don't have. They brought to the table the production and marketing, and I brought to the table the writing. And I think that was a good match.
Yeah, that to me is arguably as difficult as the writing. You're a lawyer.
Sure.
You were a litigator for a decade or two before you started writing this book, and here you are being asked to not just be a writer, but theoretically be a book publisher, be a book marketer. And without that assistance from PLI, who knows how much you could have done yourself getting off the ground. So to wrap this chapter up, pardon the pun there, tell me how long from you starting to write until there being a beautifully published book for you to hold in your hand and say, I made this?
I think it wasn't that long. It was about a year, I think, maybe when the first edition came out. They were pretty good about turnaround. You know, I'd send them files, they'd make some changes, send me some things back. So maybe it was a year, maybe it was a little bit longer than a year. Now our annual process is a lot faster than that. I give them something in June or July, and the edition comes out in September or something like that, or October maybe. But they were actually pretty quick. And so, yeah, I think it was about a year.
Did you have to run this by your colleagues at Deckert, whether it was your practice group people, your, anybody on the management committee? I'm curious. obviously you're a partner there, so you have some autonomy in the things you do and the way you build your book of business. But I'm curious, how much of this had to be run by your colleagues at Deckert before you got the go ahead to actually start the process?
I did. I ran by the practice group leader. I wouldn't have wanted to do something like this without the approval of the firm. And so I did ask the practice group leaders. We talked about it. They approved it. And then, of course, a PLI, a publisher is going to send you a contract. So you got to send that to the general counsel of the firm. But I made sure. I was also very careful. And people have different ways of looking at this, because if you look at some books that lawyers, have the law firm's name on the front of it, especially with something like this, I didn't want that. And I don't think it would have been good for the firm either. I wanted this to be my book, not the firm's book, in the sense that one concern I have about writing a book like this, and I think everybody should really think about, is ultimately when you write a book, you're going to have to take positions, right? You're going to have to say the law is this or the law is that. And that's potentially problematic at a big law firm, because what you don't want to happen is for one of your partners in some other office to go into court, and the other side writes a brief that says, oh, look, your law firm wrote a book that says that the law on this particular subject is X, and now you're coming into court and saying it's Y or not X. And so I think that's one issue to think through, right? Is how much do you want the firm on the hook for what's said in the book? And so I was careful about that the book was written by me, they're my opinions. And so if somebody wants to hold me to them, that's fine. But I didn't want other people in the firm to have to deal with that.
It's funny you mentioned conflicts or possible conflicts arising out of the marketing and business development work that lawyers do. I've advised clients, and I wrote a blog about this, I'll put it in the show notes, about running conflicts checks on your client alerts and your bylined articles for legal industry publications, because you never know how your seemingly objective opinion regarding a recent Second Circuit case or Ninth Circuit case can come back to bite you and your colleagues 3-4 years down the road, when you are in a position, or where your colleagues are in a position to take they're in a position to take a position contrary to what you may have taken in an article where you simply just said, it looks like the court said this because, and it appears a trend might be XYZ. So it's sneaky, but you have to remember, you don't know how things are going to be framed and used against you, your law firm's clients down the road. And when your content is public record and easily citable and easily accessible, you just never know what could happen tomorrow, next week, next year when it comes to your content. So that's a very interesting point. And I would hope attorney-client privilege is not exactly the most adversarial type of law, and it's not really a matter of interpretation, plaintiffs versus defendants. It's a pretty, I would think, a safe area to avoid conflicts in, if you are looking at it as a whole.
It's safe to avoid conflicts in terms of client conflicts, but the problem is it's not safe in terms of issue conflicts, because there are lots of gray areas in the attorney-client privilege all over the place. And when you write a book, you have to say, it looks like the trend is this, as you said, or sometimes you say it looks like the right answer is the following. And we're talking about something that is severe in its consequences, right? To say that a document is privileged or not privileged can have case dispositive implications in some cases. When you go into court and you say, I think this document is privileged and here's why, you're making an argument, and there's usually an argument on the other side. And so that's what I was concerned about. And that's why I wanted to be, there was nothing I could do about it in terms of writing the book and predicting future outcomes for myself. But, and I did have somebody once cite my article against me. I don't think they quite understood it, but they did, and it ended up being okay. But I just didn't want my partners to have to deal with that. And so I think the question of whether you put your own name on the front cover or the law firm's name on the front cover is something to think about.
We've spent a lot of time talking about the machinery, the efforts to write this book. So you have this book now. It's published about a year after the whole process started. You have this book. Talk to me a little bit about the marketing and business development efforts around the book, the benefits you received from the book, and how it may have changed your practice now that you have this book to show people and remind them of the work that you do and the authority that you have based on publishing it.
Yeah, it's interesting because on the one hand, it's not like writing a book on securities law, let's say, because in that sense, you can say I'm an expert in this area of the law and you should hire me for your case that involves securities, right? So I didn't have that going for me because there are very few instances where I could say to somebody, hey, you've got a case that really involves attorney-client privilege, so you should hire me. So it didn't work that way. But what I liked about it was that the privilege applies to every lawyer. So what I could do was get introductions to people to give a CLE. I developed a CLE that I gave many, many times on the attorney-client privilege and in-house lawyers. And I would give this, and every in-house lawyer in the company would show up because if you give somebody unemployment, some people might be interested, some might not be, but this applies to everyone. And so I had the authority behind me of being the author of the book. So when I say, hey, I'd like to give you this CLE, it's not just I'm just some person who developed a CLE. It's I'm this person who developed a CLE, and oh, by the way, I wrote the book. And so that provided me some really good opportunities. I also just PLI's marketing alone. I got emails, and one in particular, I got an email from the general counsel of a pretty big company who just got PLI's email, and his assistant wrote to me and said, "Would you be willing to come over and give us a CLE?" And I said yes, and that relationship ended up developing work, actually not for me personally, but for someone else at the firm through an introduction I made to that person who I met and then to somebody at the firm. So it was a really good way to touch base with clients, with potential clients, and to, giving a CLE, I think is great because you get to go over there, you meet people, you go to lunch, at least you used to do it that way, but there were a lot of doors that were open because of the book.
You raised a couple points I want to touch on. One is the fact that this topic is not just end client focused. This is something that other attorneys need to know as well. So it becomes a referral marketing tool as well, because you don't have to go to general counsels at large companies. You could go to attorneys in your network and market the book to them, or at least use the book as a way to reintroduce yourself or remind them that you're still there, and maybe get them to have a cup of coffee or lunch or what have you. The second point, which is interesting, which I didn't appreciate until you just mentioned it, is that you're able to piggyback off of PLI's marketing infrastructure, their sales infrastructure. We touched on this earlier about you writing versus them publishing and marketing it. But if you are getting your book published by a LexisNexis, a Westlaw, a PLI, another kind of large entity that really is good at marketing and sales, but more importantly, already is touching thousands and thousands of lawyers, in-house and private practitioners alike, that gives you a huge leg up. And it really allows you to get into those people's inboxes and get in front of them without you having to do much of the grunt work that you would normally do if you were trying to market the book yourself.
Oh yeah, trust me. And I know that from personal experience too, because as you might know, I just wrote a book on a topic completely unrelated to the law, and I self-published it, which is fun and it's fine, and I'm happy with it. But I've tried to do some marketing for that book, and I actually have, and it's been all good, but it requires a lot of work. It requires time. And you're talking about, again, being at a law firm and being busy already, and you wrote a book. I just can't imagine what it would have been like to have to try to sell the book and market the book. And so, yeah, I'm very happy with PLI. Let me put it that way. I just think they do a great job. I personally am a big fan of theirs just in general, because I think that their CLE programs are really good. So I was very happy to have them do all these things. And then, yes, you benefit from their marketing.
Tell us about your book that you just published.
Oh, so in my free time, I love wine and I study wine. I've spent a lot of time studying wine and drinking wine, and wrote a book on champagne called Press for Champagne, which is on Amazon. And it was a labor of love. I loved writing that book. I'm happy with the book, and a lot of people have told me how much they've enjoyed the book. It's a book for wine drinkers to get. I'm going to tell you how to get more joy out of champagne, and it's a totally different endeavor, but that's my other book.
Well, we'll certainly put links in the show notes to the book for anybody who wants to buy it and benefit from your knowledge beyond attorney-client privilege. Would that book have happened had you not written the attorney-client privilege answer book?
It's a good question. I don't know. It definitely writing the privilege book gave me the confidence to know that I could write a book. And then, and of course, this is a very different book. It's written in a very different style and tone than the privilege book, but as you would hope. But I knew how to write a book. After I wrote this book, I knew what was required. I knew the work that would go into it. And so I don't know if I would have written this book. I definitely think that my experience writing the privilege book helped me in organizing myself and writing the champagne book. Again, even though it's just such a different book in so many ways.
Are there any more books inside of you?
I think there is one other book that I'm thinking of, but it's still in the very, very early stages of thinking about it. So we'll see what happens.
I want to wrap up with just a couple more questions. I'm curious, did this book lead to any additional client opportunities and actually clients coming into your practice or your colleagues? You mentioned one earlier, but are there any any additional ones where you can draw a direct line between the book and this client relationship?
There are that I think I can, and I say I think I can because I didn't have anybody tell me directly, we're hiring you because you wrote this book. And again, I think if the book had been about antitrust law or securities law, it would be easier to draw that line. But I can think of an example where there was somebody who I had lost touch with, isn't the right term. I just hadn't connected with as much. And even though I tried to, but then again, I wrote the book and I said, hey, here's the book. I have a CLE, and this woman, brought me in and I gave the CLE. Everybody loved it. You have to deliver. That's the thing. And of course, the CLE has to be good and people have to like it. But she thought, wow, that was amazing. And not long after that, I got hired for something. So I think the book is part of a chain of events. It's just, you can't just, and I know you know this, but you can't just write a book and then sit back and decide that, well, now the cases are just going to start rolling in. You have to continue the momentum, and you have to use the book as a tool to help people and give them information that they think is interesting and valuable. And you have to do it without the expectation of a reward. I gave the book to a lot of people and did CLEs for a lot of people who never sent work my way, and that's totally okay with me. I didn't try to have this quid pro quo with anybody. I just thought I'm going to try to do my best to contribute, to help. And if people see the value in what I can provide through that, then that's great.
You make an interesting point, which is that even with a book, even with your ability and your position at a large law firm, people still hire other people they know, they like, and they trust. And there might be 4 or 5 other big law partners who are vying for that same client, or at least in that client's orbit. They may have been doing similar CLEs. Sometimes you need just the slightest advantage in that know category, that like category, or that trust category. And for some people, it's an attorney-client privilege answer book. And guess what? For some people, it might be the champagne book. And people go, wow, Chris seems like a great guy. And hell, he wrote a book about champagne. I love champagne. That things like that you wouldn't think could put you over the edge in terms of competing and winning business, they might very well. And I think it goes to show that we can talk about content marketing and thought leadership marketing in terms of our knowledge and our wisdom, but it's important that we also show some personality at times, because people work with other people they like. And if they're going to be stuck in a conference room with you as a mediator for a couple hours, or they're going to be over Zoom with you over various sessions, they need to have a connection with you. And if it's just business, if it's just sterile like that, there's no guarantee it's going to win, or you'll have a chance to win that client over. But again, show your personality. It could be a different story. So that's a really interesting point about how the book gets you in the door, You still have to produce, you still have to come with the goods, but it merely being a door opener is an advantage that you may have not had but for writing the book.
Yeah, I agree with you 100%.
Chris, we're wrapping up here. What are some things you wish you knew before you started this process that you know, obviously, now?
Yeah. Well, I'm not sure there's something that I wish I knew, because I think I understood at the time something that is really important, which is that the book is not going to be something that is going to be easy to write, and it's not going to be something that's necessarily going to have a direct result in terms of getting business. And I think as long as you understand those two things, you're going to be okay. I think the people who really are writing the book because they think that it absolutely is going to have some kind of a payoff are potentially going to be very frustrated. And as long as you can just drop into the idea of, I'm going to do this, I'm going to get a result in terms of the book, and then whatever happens with it happens, and I'll do the best I can, then you're going to be okay. And that's what I tried to do.
That's great advice. And I would have normally ended this conversation by asking you one tip of advice for our listeners, but I think you nailed it. So, Chris, I really appreciate you taking the time to get pelted by questions about writing a book as a BigLaw partner. Before we exit, can you give everyone your contact information if they're curious and learning more about your mediation firm, your books, anything else that they might want to learn about you? How can they reach you?
That's great. I appreciate it. Well, I'm on LinkedIn. You can find me pretty easily by searching Christopher Ruhland. It's Ruhland on LinkedIn. And my website is apolloresolution.com. And my email address is chris@apolloresolution.com.
And we'll put that all in the show notes for this episode. Chris, again, thanks so much for taking time to chat with me.
Thanks, Wayne. I really enjoyed it.
Well, that's a wrap for this episode of Legally Contented. Thanks so much for tuning in. Check out the episode show notes for more information about our guests and for links to resources that we discussed during the episode. We'd appreciate your feedback and recommendations for future guests. Email us at hello@legallycontented.com, hello@legallycontented.com. We would appreciate if you told your colleagues about this podcast, if you subscribe to the podcast and urge them to subscribe as well. And while you're at it, maybe you could even rate and review the podcast on your favorite podcast player. Until next time, thanks so much for tuning in to Legally Contented.